When is legal counsel considered ineffective assistance? Imagine being in court, trusting your lawyer to fight for your rights, only to find out they might not be doing their job properly. That's a serious concern. Legal counsel is considered ineffective assistance when a lawyer's actions fall below the standard of competence expected from attorneys, and this causes harm to the defendant's case. This means the lawyer's performance must be objectively unreasonable compared to what other lawyers would do in similar situations. If their mistakes or omissions likely change the case's outcome, it's a problem. For example, if a lawyer fails to investigate important evidence, it can hurt the defense. Not calling key witnesses or giving bad legal advice about pleading guilty can also be signs of ineffective assistance. The Sixth Amendment guarantees the right to counsel, but it also guarantees the right to effective counsel. Having a lawyer present isn't enough; they must be skilled and diligent. To prove ineffective assistance, a defendant must show two things. First, that the lawyer's performance was unreasonable compared to what is normally expected. Second, that this poor performance prejudiced the case, meaning it probably affected the verdict or sentence. Courts look at these cases carefully and tend to give lawyers some leeway for strategic decisions. But if the lawyer's errors are serious enough, it can be grounds for a new trial or other remedies. Common examples include a lawyer not investigating evidence that could help the case, or advising a client to plead guilty without explaining the consequences properly. If a lawyer has a conflict of interest that affects their judgment, that can also be a reason for a claim. Ineffective assistance claims can come up at different stages, like during trial, sentencing, or plea bargaining. For instance, if a lawyer's bad advice causes a defendant to reject a good plea deal or plead guilty without understanding what they're doing, that might be considered ineffective assistance. If proven, remedies can include a new trial, a new sentencing hearing, or even reoffering plea deals. The goal is to make sure the defendant's rights are protected and that they get a fair chance to defend themselves. Remember, knowing your rights means understanding that you are entitled to a lawyer who performs competently. If you believe your lawyer's mistakes hurt your case, you can challenge your conviction or sentence by showing specific acts or omissions that fell below reasonable standards. This helps ensure your right to a fair trial is respected, and that your defense isn't just a formality but a real safeguard in the justice system.